here in the Baltic region, and Latvia and Slovenia. So, European Commission normally mentions this fact as a problem, but of course without evaluating the possible solutions, because actually the European Commission really believes that this is outside of the EU mandate. But let's try to get this picture of how this situation arose in the Baltic region, and maybe speak about some possible solutions also at the European level. So, after the collapse of the Soviet Union, you have to notice that the Baltic states weren't new states. In 1940, all the three Baltic states, Estonia, Latvia and Lithuania, were occupied by the Soviet Union and later illegally incorporated into the Soviet Union. So that's why when the pro-independence movement in 1980s and the beginning of 1990s actually got a very huge popular support, the idea was not to create new states here in the region, but to restore this independence which existed until 1914. And in 1990, all the three Baltic states adopted the declarations on independence, and in 1991, this independence and restoration of independence was recognized by the international community, and all the three Baltic states joined the United Nations. But of course, the question arose that if you are a state, you have to define who your citizens are. And since the state was restored after, in fact, 50 years, it was quite difficult to decide on the citizenship because, of course, there were people who lived there also before this loss of independence, before 1914. But in the Soviet Union was a unit, in fact, a single state, and people enjoyed the freedom of movement inside the state. So that's why a lot of people from other parts of the Soviet Union moved in the Baltic region, into Estonia, into Latvia and Lithuania. And of course, the first idea was to restore citizenship to those who possessed the citizenship until 1914 and to their descendants. And this was the concept adopted in all the three Baltic states. The first state adopting the citizenship law was Lithuania in 1989, and then they adopted a new version of this law in 1991. In Latvia, they adopted the first, not really law, but decision on the restoration of citizenship in 1991, and then adopted the full citizenship law in 1994. And in Estonia, in 1992, it was decided to restore the act of the citizenship law 1938. So, people who had been citizens of the Baltic states before 1940 and their descendants got the citizenship, but as I told, quite a big number of persons moved from other parts of the Soviet Union, and it was to be decided what to do with them, and it was to be decided whether they are entitled to get the citizenship of restored Baltic states. And here, actually, we can see that there were certain political choices, and certain political choices depended a lot on the situation on the ground. The most liberal concept was in Lithuania, because in 1989 it was decided to have a 2-year transitional period during which people who moved in during the Soviet period were entitled to choose whether to be registered as citizens of restored Republic of Lithuania. And actually, a huge majority of people decided to opt in and decided to be registered for the citizenship of Lithuania. In Estonia and Latvia, the situation was quite different. And there was several factors behind this, but, well, in my opinion, the most important was political factor. First of all, if you compare the situation in Lithuania, this number of people who moved in during the Soviet period was higher, and you can see that after the restoration of full citizenship laws, in Estonia and Latvia only about 68–70% of the population got their citizenship restored, and it meant that actually around 1/4 of the population were people who moved in during the Soviet period and the people whose citizenship was to be determined. And it created quite tricky situation from a political point of view, because, well, for many politicians in the Baltic states believed that actually these people had to be even deported to Russia, for example, as successor state to the Soviet Union. Others believed that yes, they can live there, but they have to fulfill certain requirements in order to demonstrate their loyalty towards this really restored independence. And there were also politicians who believed that actually the same concept as in Lithuania was to be adopted. And finally, in Estonia and Latvia, it was decided that yes, these people basically have the right to naturalization, but this naturalization will not be simple registration as in Lithuania, but the people have to pass the exams in the official language, in the history of the correspondent states, give some promises of loyalty, and only after that they are entitled to get the citizenship. And in fact, naturalization as such in Estonia started in 1993 and in Latvia in 1995. So for some years, people who lived there without their citizenship restored, who moved from our parts of the Soviet Union, they lived in a kind of legal vacuum, because first they didn't know what would happen to them. Second, even after the decisions on naturalization had been adopted, they didn't know what the requirements for naturalization would be. And I have to mention also that the first rules on naturalization in Estonia and Latvia were quite restrictive. It meant that we applied the system of so-called quotas, and it meant that only a certain number of persons would naturalize during 1 year. And the system of quotas was abolished in Estonia and Latvia under the pressure of European organizations such as the OECD and the Council of Europe. Also later, to a certain extent, also the European Union created some pressure on the Baltic states, but those quotas were abolished only in 1998. So what happened to the people who remained without citizenship and were entitled to be naturalized, with some limitations, with some rules, with some requirements? It appeared that the solution, which was hoped to create results by the international community, didn't create the real results in the Baltic states, because you can see the statistics for 2012 that in Estonia more than 6% remain stateless, and almost 9% of the population are foreigners. And among those foreigners, the majority is citizens of Russia, because many people who remained without citizenship in Estonia, they opted for Russian citizenship. In Latvia, the situation is a bit different. We have 14% of so-called non-citizens, Boris referred to, and this is a kind of special status. Latvia doesn't recognize them as stateless. This is something in between the status of stateless persons and nationals. We have 175 persons stateless and about 3% of foreigners, because the main difference between Estonia and Latvia was that for Estonian stateless persons, for Estonian non-citizens, they were obliged to request for residence permits in Estonia. But in Latvia, this legal status of non-citizens created the rights of residence in itself, so people didn't have to apply for residence permit. And that's why in Estonia many believe that there is no difference between this status of stateless person and the status of a foreigner, because in both cases you have to apply for a residence permit, so why don't people have this citizenship of another state, and predominantly it was Russia. And in Lithuania, you can see that approximately 3,000 persons remain stateless, and less than 1% is for foreign population. So, yeah, as I mentioned, in situation in Estonia and Latvia is quite different because of this fact that in Latvia, non-citizens, they don't have to request a residence permit. So, what are the issues? Why this situation is problematic from the human rights point of view? First of all, as you can imagine, since stateless persons in Estonia and Latvia are predominantly people of minority origin who moved in during the Soviet period, it meant that you have to take into account this factor when you are considering the policies in the field of minority rights. And the dominant concept of minorities in this region is that, to a certain extent, we recognize minority rights only for persons who are citizens of a state. There are some exceptions in both Estonia and Lithuania, Estonia and Latvia. Some exceptions are legal, some exceptions are factual, but still the predominant view is that minority rights are guaranteed to those who are citizens. And if you calculate ethnic proportions, for example, in some municipalities, you can see that if you take into account only citizens of minority origin, you confront one situation. But if you take into account also the number of non-citizens belonging to the same ethnic groups, the situation looks quite different. So that's why this issue of citizenship is very much related to the issue of minority rights of origin. Second thing is political rights. Again, non-citizens or stateless persons are not entitled to vote in national elections, to vote and stand in national elections, and also in the European elections in the Baltic states. As regards municipal elections, the situation is different. There are voting rights for stateless persons in Estonia and Lithuania, and candidacy rights in Lithuania. In Latvia, despite the number of stateless persons is the highest, they don't have neither the right to vote, nor the right to stand for elections, for municipal elections in Latvia. And it also creates some practical problems because, for example, in Latvia we have some municipalities where the number of non-citizens is extremely high, almost up to 50% of the population, and it creates some risks in terms of legitimacy of the local government. Also, as regards economic rights, it created some problems because normally jobs in public sphere, in public sector, are reserved for citizens, and also there is a problem as regards some jobs in private sector as well. For example, in Latvia, we have some discussions about whether advocates or notaries could be persons belonging to this category of non-citizens. But, well, since the state believes that they implement some state functions, these jobs are reserved for citizens. Also, there are some limitations as regards land ownership and, of course, the freedom of movement inside the EU, because this freedom is guaranteed only to the EU citizens. Since all stateless persons are not EU citizens, they don't enjoy such a right to free movement in the EU. And last but not least, in some Baltic states there are some problems related to social rights. And for example, here I can cite one case against Latvia in the European Court of Human Rights, because there were different principles for calculation of the state pensions for citizens and non-citizens in Latvia. The European Court of Human Rights in this case decided that actually Latvia is the only state which is responsible for non-citizens of Latvia, so that's why there should not be discrimination on the grounds of citizenship, but still this judgment of the European Court of Human Rights is not properly implemented. So, what are possible solutions? Well, in the very beginning, the international community and the European organizations, they believed that, well, there is a certain agreement that people, stateless people, were entitled to live in the Baltic states, and naturalization, especially after the abolition of quotas mentioned by me, would solve all the problems. But unfortunately, it was not the case due to very different reasons. Now, the process of naturalization almost stops in the Baltic states, and factors are very different. But one of the factors is that stateless people, they are quite alienated from the state. They lived in legal vacuum for several years when there were quotas. Afterwards, maybe for some people, the examinations represent some problems. So that's why the status quo remains in place. And in theory, the UN, the Council of Europe, also to a certain extent the European Commission, they recognize that this is a problematic situation, but there is no actual political will to do something in this domain. But probable solution could be, first of all, easier naturalization, of course. If it doesn't work for the time being, then maybe it could work if the requirements are easier. But it creates, first of all, it needs some political will in order to promote naturalization. And second, there could, for example, in Latvia, a question arose when there was an idea of popular referendum on the issue of naturalization without examinations in Latvia, and the Central Election Commission decided that this question cannot be put to the vote, to the popular vote, because it is at odds with the principle of state constituency, with the principle of restored citizenship. In other words, the Commission decided that it is not allowed to provide naturalization without examinations in Latvia. And of course, it is quite difficult to accept, taking into account the Lithuania situation, because in Lithuania the solution was different, but still it didn't create any risks for the doctrine of state continuity in the case of Lithuania. But it seems that in Latvia the authorities, they believe in continuity, in a different concept of continuity. Second thing is, of course, possible solution which we will discuss after the break, which is, yes, Jean-Pierre, which is EU citizenship based on residence. If we don't have a political will at the level of member states, maybe some problems will be solved through this newly developed concept of EU citizenship based on residence, not on citizenship of member states, but of course it would require quite significant changes to the EU treaties. And whether it is feasible or not, it's hard to decide. So, fourth thing, in order to promote at least some rights for stateless population, would be that the Baltic states, Estonia and Latvia, for example, could declare that for the purposes of the EU law, they recognize that stateless population is to be considered as nationals of the Baltic states. It wouldn't solve all the problems, but at least the problems which can be solved through EU citizenship and the rights of EU nationals. But again, there is a need of political will at the local level to present such a declaration to the European Union. Another possible solution is not to declare that these people are fully fledged EU citizens, but to recognize some rights which are normally guaranteed with the EU nationals, but not exclusively. And here I can refer to one interesting case in the European Court of Justice, Spain against the United Kingdom, where the United Kingdom provided for the right to vote in the European elections to the residents of Gibraltar, which are not legally speaking within UK nationals within the meaning of the EU law, because they are not included into a particular UK declaration under the EU treaties. And Spain protested against this solution. It was necessary for the UK in order to implement the decision of the European Court of Human Rights in the case Matthews against the United Kingdom. But the European Court of Justice declined this claim of Spain, saying that if certain rights are guaranteed to the EU citizens in the EU treaties, it doesn't mean that member states are not entitled to provide the same rights to other persons who have strong links with particular member states. And of course, you can imagine that stateless population in Estonia and Latvia, they have quite strong links with corresponding states. And in Latvia, it is even recognized by the Constitutional Court. It is also recognized by the European Court of Human Rights, in this case, Andrea against Latvia. So that's why, to a certain extent, it could be another creative solution. But again, it requires political will at the level of member states. Another thing which can be imposed about this is equal rights at the domestic level. For example, if now you have a lot of differences in rights between citizens and stateless persons, this difference can be diminished. But again, it requires a political will. And the last point would be that people who are stateless in the Baltic states, they normally could qualify for a status of long-term residence for the purposes of the EU law under Directive 2003/109. And in accordance with this directive, certain rights are to be equalized, and in particular the right of free movement inside the EU, the right to work, for example, in other EU member states. But there is one but, again, that this directive provides for a possibility to introduce some so-called integration requirements in the domestic legislation. In other words, for example, in Latvia, when we implemented this directive, it was decided that in order to get the status of long-term resident, it is necessary to pass the examination in the official language. But again, why should a person pass this examination in the official language in order to move to another country? This is one practical thing. And another thing is that actually, if you have in any event to pass this exam, it's why shouldn't you pass this exam for purposes of full naturalization, for purposes of getting this fully fledged citizenship and fully fledged EU citizenship? That's basically it. It was my last slide. Thank you very much for the attention. Of course, it was